This case starts with tension already in the air, and it only gets worse from here. A landlord claims months of unpaid rent, while the tenants fire back with serious allegations about mold, water damage, and unsafe living conditions. On paper, this looks like a standard eviction case, but once the details start coming out, the story gets messy fast. Conflicting timelines, missing payments, and claims that don't quite line up. And then comes the twist: a courtroom agreement that should have ended everything completely falls apart. The judge? Not impressed. Not even a little. And by the end of this hearing, what started as a dispute turns into a full-blown reality check. The question is, were these tenants truly wronged, or did they push their luck too far? This case starts with tension already in the air, and it only gets worse from here. A landlord claims months of unpaid rent, while the tenants fire back with serious allegations about mold, water damage, and unsafe living conditions. On paper, this looks like a standard eviction case, but once the details start coming out, the story gets messy fast. Conflicting timelines, missing payments, and claims that don't quite line up. And then comes the twist: a courtroom agreement that should have ended everything completely falls apart. The judge? Not impressed. Not even a little. And by the end of this hearing, what started as a dispute turns into a full-blown reality check. The question is, were these tenants truly wronged, or did they push their luck too far?
On this, Mr. Butler?
Currently $5,500.
You gonna be able to pay him?
Yes.
Yes.
When?
It's, I don't know.
There's a
Right out of the gate, the judge is setting the tone, and it's not looking good for the tenants. The number being thrown around is $5,500 owed, and the first thing the judge asks is simple: can you pay it? That question matters more than anything else in eviction court. Because legally, if you owe rent and can't pay, your defense needs to be rock solid. And right now, the tenants hesitate. They say yes, but then immediately follow it with "I don't know when." That contradiction is a red flag. Courts don't operate on uncertainty, they operate on clear ability or inability. So already, before any defenses are even presented, the judge is seeing hesitation. And here's the key question: if you can't clearly explain how you'll pay what you owe, are you already losing credibility?
There's many things that go along with this.
Well, let's hear it.
it's a habitability concern, sir, Your Honor, and that's what we're not withholding the rent by any means, but
Slow down.
There's an inspection that's not.
Slow down.
we started with a
Slow down.
home
Wait a
inspection.
minute, let me
Okay.
talk. Let me talk.
Yes, sir.
What kind of habitability issue?
Water intrusion in the basement that has created mold, and the air quality is a significant concern.
Have you been there?
Yes.
How?
How long?
Yeah.
August.
August.
So you've been there 4 months and you haven't paid a nickel yet?
No,
We've paid.
we paid 2 months rent.
So you didn't pay for October, November, December, or January?
We paid. No, we just owe for November, December, and January.
Now the defense shifts to habitability issues, and this is where things get serious. Claims of mold, water intrusion, and even a child having allergic reactions can absolutely justify withholding rent, but only under very specific legal conditions. The property must be proven unsafe or uninhabitable, and tenants usually must notify the landlord and give them a chance to fix it. But here's the problem: the judge immediately spots a contradiction. The tenants claim the property is unsafe, yet they admit they've still been staying there. That weakens the argument significantly. Because legally, if a place is truly uninhabitable, you typically don't continue living in it. So now the judge is digging deeper. And the big question becomes, is this a legitimate safety issue, or a defense that doesn't fully hold up under scrutiny?
December and January.
Yes, that's correct. 3 months.
Is that right? Did they pay you for 3 months, Mr. Butler?
Yes, and they were late all 3 months.
Mr. Robertson, I'm gonna adjourn it 1 week. Don't be shocked if I tell you guys I want to come over and see it. I'll adjourn it 1 week to February the 3rd, is it, or 2nd?
Second, Your Honor.
We'll give you the phone number of the lawyer. You
Okay.
can call. But have you guys had to be out of the house any nights?
You know, Your Honor, I don't want to waste your time, but yeah, there's significant concerns. My son, had a
You don't-
severe allergic reaction. He was completely healthy. That's documented with, medical. That's happened twice.
Okay, so
We
just so
haven't
you
not
know,
stayed in the home overnight strictly because of it, because of
The size of our family.
the pending concern or not knowing the exact
where are you now?
in the residence.
Well, wait a minute. I thought you weren't spending the night there.
No, I said we have always spent the night. I apologize. We have not.
So
State of-
if it's uninhabitable, that means you can't live there. That means that there's a proportionate reduction in the rent. Just don't be shocked if I ask you if you have a problem with me coming over there next week. In fact, I'd bet on it, okay?
You're more
So
than
get-
welcome, Your Honor.
Start getting your money together, talk to the lawyer, and I'll adjourn this until.
This moment is subtle, but powerful. The judge mentions possibly personally visiting the property. That's not common, but it tells you something important. The court is taking the claims seriously, but also wants verification. Judges don't rely on emotions or descriptions. They rely on evidence. By suggesting a visit, the judge is signaling, if this is as bad as you say, I want to see it myself. That raises the stakes dramatically. Because if the conditions don't match the claims, the entire defense collapses. And at the same time, the judge is advising the tenants to start preparing money. That's a huge hint about how this case is leaning. So think about this. When a judge says they might come see for themselves, is that a lifeline or a warning?
Adjourn this until that day, February the 2nd at 11 o'clock in the morning.
Are we on, Anthony Butler? And then there's also Skylar Crenshaw, Skylar Crenshaw, that's an occupant versus Paul Robertson and Shauna Robertson, 2600122. Could I have everybody's name again, please? Everybody's name?
Yep, Anthony Butler.
Skylar Crenshaw.
Paul Robertson.
Shauna Robertson.
All right. You sent me a bunch of materials. Again, I just didn't have a chance to review them. Tell me what you're saying, sir. Mr. Robertson.
Yes, Your Honor. I sent a letter to the court. That was the final document that I included that really emphasizes everything, but respecting your time, what exactly are you or what information?
Tell me, first of all, remind me when you moved in.
We moved in August of 2025.
August 1st?
No,
I don't remember.
I don't. I have that.
You guys ever
I'm not
written
exactly-
lease?
It was through that. It was
Yes, through an app.
Did you both sign it?
Yes.
Yes.
Mr. Butler, you can answer too. So how much was the rental rate?
$18.50 a month.
And can you tell me, Mr. Butler, when they moved in and what the first day of the lease was?
The first day of the lease was August 1st, but they started moving stuff in the weekend prior.
All right, so $18.50 per month. Did they pay a security deposit?
No, they did not.
Did they pay the first month's rent?
Yes, they did. End of August, they paid.
Did you get an opportunity to see the place, Mr. and Mrs. Robertson, before you moved in?
Yes.
We did do a quick walkthrough, but we did not understand the background, or were not told exactly, or the outstanding issues in the basement, the water, the outstanding.
Tell me exactly what the
Inspections.
issue is with the water.
It's
Our stuff.
there's been a significant amount of damage to our personnel effects.
That we,
I
I just
know,
didn't, we didn't know.
caused by, hang on. Caused by what?
Mold
And
and the intrusion of the water leaked all over the basement floor and
It's in one area of basement.
Come on, guys,
Damage.
you gotta explain to me, otherwise we're gonna be here all day. You got a basement. What corner of the basement is the water penetrate through? Is it coming through the walls? Is it coming through the drain? What's the issue?
it's coming through the walls and also through the floor, and I'm not exactly sure where the exact
This corner though.
culprit is or where the
Now we're getting into the details, and this is where cases are won or lost. The judge starts asking very specific questions. Where is the water coming from? When does it happen? What exactly is damaged? And the answers? Vague, uncertain, not exactly sure. That's a problem. In court, general complaints don't carry weight. Specific, documented facts do. The tenants describe moldy belongings and water damage, but they struggle to pinpoint the source or timeline. Meanwhile, the landlord denies ever having these issues reported before. So now we have two completely different narratives, and only one will be believed. And here's the key issue. If you can't clearly explain the problem, how can you prove it exists?
or where the
All right, so when does it happen? When we get a bad rain?
Yeah. Yes, or snow, but it looks like, I mean, it's just, we have moisture bags hanging down there since we came across this issue and we started moving our stuff into the room that once the door was fixed, we started going through the things that we had and trying to put our room together and a lot of our personal belongings. That's when we came across this in the basement is when, we started going through the stuff. We found the mold and we had stuff that was in a contractor bag that was completely molded and soaked of moisture. And so we had boxes of things that it's just one corner of this basement down in the basement. Where most of our
Butler, when did you move out of the property?
We moved out 2023.
Did you have other tenants in there between 2023 and August of 25?
Yes,
How many?
just one.
Did you have any water issues when you were living there?
I did not.
Did any tenant prior to the Robertsons complain of water issues before the Robertsons moved in?
No, Your Honor.
So you never heard any issues with regard to water?
No, this is the first time they brought up the water issue. So I'm not sure when they sent.
You never heard about it the whole time?
Correct.
Is that right, Mr. Roberts?
Here's where things get interesting. The landlord admits there was a city inspection notice requiring exterior waterproofing, and that changes everything. Because now there is documented evidence that some issue existed before the tenants moved in. But the timing becomes critical. The property was being sold, not rented, and the issues weren't fixed before the tenants moved in. That opens the door to a serious legal question. Were the tenants properly informed? If they weren't told about known issues, that could strengthen their case. But again, it comes down to proof and communication. Did the landlord knowingly rent out a property with unresolved problems? Or were these issues minor and unrelated to the tenant's claims? This is where the case becomes a true gray area.
Right, Mr. Robertson?
No, that's completely incorrect because there's an outstanding inspection that states that water damage that needs to be waterproofed. And that's where the big disconnect is that's what I'm trying to mainstream, put on the same page is there was an outstanding inspection. This was not even listed as a rental property. And
I know. But
significant amount of
was done. Tell me when the inspection was done.
They just came out to relook at the inspection that was done, that was still pending, that wasn't done, I guess, when they tried to sell the property. So this house wasn't listed as a rental, that's what the city told us, so they had to come back out and do another inspection.
Slow down. When did you try to sell the property, if so, Mr. Butler?
We had the house listed from June up until the time they moved in. We took it off the
June of
market.
25 to August of 25?
Correct.
Did you have, did the inspectors come out to make sure you were going to get a C of O?
Yes.
Did they report anything wrong with the water issue in the basement?
Just that exterior waterproofing was required. on the
Okay.
report.
And when did you get that notice?
This was June 4th.
Do you have pictures, sir? I'm sure I didn't read any of this, Mr. Robertson. I'm sure you've taken pictures of the water damage and the personal property damage, right? Of course you would have
Most
done that.
definitely, and that has been uploaded to the system. I also have taken several pictures of the HVAC and the furnace filters that are speak for themselves. But my major issue is none of this was.
Hang on a second.
Okay, I'm sorry. Go ahead.
Furnace filters. What do you talk about the furnace filters for? I mean, that's easily replaced, right?
We have.
Your Honor, I just
I'm looking at a
that
picture
was a
here.
We have been replacing that.
I tell you what, I think I want to come over there and see the place. You never said a single word to Mr. Butler about the water before you moved in? Mr. Robertson?
We didn't.
Do you mean before moving in, I wasn't aware of any of the outstanding?
The judge is now zeroing in on credibility, and this is critical. He points out that the tenants never mentioned the water issue before moving in, and possibly not even in earlier hearings. That inconsistency is dangerous. In court, timing matters. If a serious issue suddenly appears late in the case, it raises suspicion. The tenants insist they weren't aware of the problems, but the judge is clearly questioning that timeline. Meanwhile, the landlord claims this is the first time hearing about it. So now it's not just about facts, it's about who the judge believes. And once credibility starts slipping, it's incredibly hard to recover. So ask yourself, if your story changes or comes too late, does it still hold weight in court?
We didn't even know this wasn't listed as a rental. We had no idea that there was pending inspection, like stuff that had to be done for the inspection. We were not aware of any of that.
Do I have, all right, let me just make sure I'm understanding everything here. You didn't tell them anything about that, Mr. Butler, after you got a notice from the city that the exterior waterproofing was required back in June?
So we had been planning on selling the house as is. A friend of a friend reached out to help them move in a time of need. So a lot of the stuff on our city inspection, we were just going to be listing the house as is. So some of these items weren't taken care of. And when we had unlisted the house, they moved in basically same week before we could remediate any of that to get compliant with rental certification.
And you're telling me, Mr. Butler, that the first you heard from Mr. Robertson about a water issue was when?
Today, when he needed to upload things, so.
Wait a minute, slow down. He told you this at the last court date.
Not that I recall. The original issue was air duct quality in the patio door.
You didn't mention this last time, Mr. Robertson, when you were in
No,
court?
I most certainly did.
Yeah.
And we're going to adjourn this a couple weeks, and I'd like everybody to know I'm likely to come over. So I don't think anybody has a problem with that. You don't have a problem with that, Mr. Robertson, do you?
No, you're more than welcome anytime, Your Honor.
You know, the question is whether the property's uninhabitable. I want to repeat that to you, Mr. Robertson. Now, I'm not condoning if you've got water all over the basement and that kind of thing, but I remember you telling me last time you never spent a night away from the property, correct?
No, that is correct, Your Honor.
Okay.
I have not.
So that's fine. So we don't need to talk about it anymore. I know. All right. I'm recalling Anthony Butler versus Paul and Sean.
This is a major legal moment. The judge clarifies the standard. Uninhabitable means you cannot live there. And the tenants admit they've continued living in the property the entire time. That alone weakens their defense significantly. Because courts often look at behavior. If you stayed, used utilities, and lived normally, it suggests the property wasn't completely unlivable. Now, that doesn't mean there weren't issues, but it does mean the argument for withholding all rent becomes much harder to justify. The judge is narrowing the case down, stripping away emotional arguments, and focusing purely on legal definitions. And here's the key takeaway. In court, it's not just what happened, it's how your actions align with your claims.
Paul and Shauna Robertson, 2600122. I see you're all out there. I don't want to know the status of your discussions. Are you guys getting anywhere?
Yes.
Yeah.
Okay,
Yes.
good. I'm putting you back in a breakout room then, okay?
I think we're like, we have
A tentative
Yeah.
resolution,
Yeah.
if you would like to hear that, or do you need a?
a minute.
Well, no, I don't need anything. I'm here to, you got my full undivided attention. But I want to make sure when you say tentative, have you guys agreed on this?
Yes. The only
Yes.
thing, partially.
Do you, Anthony, go ahead. Do you want to just take the?
Yeah, go ahead.
Yeah, so they're following through with moving out of the residence at the end of March 31st, we agreed on. As
Okay.
far as rent payment and what's owed, I guess we wanted to touch base with you on the judgment of that and how payment system would work.
Well, wait a second. Did you guys agree to a figure or not?
We gave him what all is owed, including our lawyer fees, and Paul
Well-
has his say
well,
in
I
not
don't
wanting
really-
to pay.
Okay, so here's the problem, guys. I don't really want to be the one facilitating a settlement discussion because I'm going to be the one who's going to decide the case if you don't resolve it.
Your
So
Honor,
I
where
don't,
we,
go
oh,
ahead.
I'm sorry. We left off where the Butlers did, or they were to, they have a documented amount and a breakdown of the outstanding rent, late fees, lawyer costs and whatnot. And we agreed that that would be emailed to us today. And then possibly I would have 48 hours or Monday just to review. And then we could come to an agreement outside of the court rather than a trial, because
Nobody wants it.
no one wants that. We're four adults. I think that we can resolve, but I think the matter of us just going back
Well, why don't
into
you
a court.
spend time resolving it now?
I don't have all the information, and they don't have all the information of all of the ins and outs or the details. That's what I would just like just to agree on a, substantial $10,000. I don't feel comfortable doing that without
Well,
some form of time.
how much is the monthly rental rate?
It's $18.50 a month,
And how many months are they in arrears?
4 months behind.
All right, so that's $7,400. I'm gonna say, I'll go along with what you're doing. I'm setting this for trial.
Now we shift from argument to negotiation, and this is where things take a dramatic turn. The parties are discussing a settlement, and the numbers are getting serious. The judge calculates roughly $7,400 in unpaid rent, and suddenly a proposed agreement of around $9,500 comes into play, including fees. This is typical. Settlements often include more than just base rent. But here's the interesting part. The judge refuses to fully mediate the deal. Why? Because if it falls apart, he'll be the one deciding the case. That's judicial neutrality in action. Instead, he sets a clear path, resolve it quickly or go to trial. And this is the moment where both sides have to decide, do we risk everything in court or lock in a deal right now?
Trial next Wednesday. I'm not adjourning it. You guys can submit figures and I'll call, we're gonna have you guys in here on Monday. And if it doesn't resolve, we're going to trial on Wednesday, period. Everybody can do that, Mr. and Mrs. Butler?
Yes.
Okay, so
Mr. and Mrs. Robertson?
Yes.
What's wrong? Did you have something to say, Mrs. Robertson?
I just wanted, so we're gonna be able to get we're gonna go over, so mainly we're meeting to file, so we'll have a judgment of how much money will be paid on Monday.
You guys can hash it out. If you don't resolve it, fine. We'll go to trial on Tuesday. Everybody good with that, Mr. Butler?
Yes, that's fine.
Mrs. Butler,
Yes.
Mr. Robertson, where'd Mr. Robertson go?
Oh, I'm right here, Your Honor. Yes, I'm fine with that.
Mrs. Robertson, you okay with that?
Yes.
Okay, so I'm gonna encourage you guys to keep talking, okay? Robertson and Shauna Robertson. Now, I don't know if you guys are gonna, if you have something that is going to tell me that this is resolved. I was told it was when I asked your name. I'm sorry, say that again? Oh, yeah. And your name?
Anthony Butler.
Your name? Your name?
All right.
You guys came up with an agreement?
Yes, sir.
Who wants to tell me what it is?
Okay, so we met, they are still planning to move out by March 31st. This Friday, the 27th, they will have $2,000,
So you're agreeing to a money judgment for how much?
for $9,500,
For how much?
$9,500.
So you're agreeing to a money judgment, the amount of 9,500, right, total?
Correct.
Let me just put all this down. All right, go ahead then.
Yep, they're to be out by March 31st. First payment they agreed on was this Friday, the 27th of.
Slow down 1 second. Let me just, I want to write this all on the judgment. So this is converting to a termination of tenancy that you're going to vacate by March 31, right, sir?
Yes, sir.
Right, ma'am? Right, sir? That's the agreement?
Yeah.
Okay. And how much what are they going to pay at what point?
They said this Friday they will pay $2,000.
Hang on. 2,000 by February 27th, right?
Correct.
Okay.
And then the next payment would be April 1st of $1,500.
Okay.
And then another $1,500 May 1st
Okay. Is it $1,500?
until it's paid off.
1,500 more by April 1st and the 1st of every month thereafter until paid in full, right?
Correct.
All right. So here's what I want you guys to do. I'm going to cover all this with you. This would be a consent, and you two sign it, and then we'll go over everything in here, okay? If you agree to it, just make sure that you understand it and agree to it.
Your Honor.
It's all signed by everybody?
Yes.
Okay, you can hand it right to her. All right, so I want to cover the terms again. You did sign and read and understand this document, Mr. Butler?
Yes.
And Mr. Robertson, did you?
Yes, Your
The
Honor.
agreement is now official, and it's very structured. Move out by March 31st, pay $2,000 immediately, then monthly payments of $1,500 until the $9,500 judgment is satisfied. This is what's called a consent judgment, meaning both sides agreed to these terms voluntarily. But here's the catch: once you sign this, it becomes enforceable like any court order. And the judge makes that crystal clear. If you don't follow through, eviction and enforcement actions will happen. This is no longer a negotiation. It's a legal obligation. And here's the reality. Once you sign a deal like this, there are no more excuses, only consequences.
Yes, Your Honor.
And Miss Robertson, did you? So you understand, according to its terms, you have to vacate by March the 31. And in addition, and if you don't, you're going to be evicted. You understand that, right, Mr. Robertson?
Yes.
Ms. Robertson? And in addition, you're agreeing to a money judgment in the amount of $9,500 with no costs assessed on that, right?
Yes.
Right, ma'am? And you understand you have to pay that at the rate of $2,000 by this Friday, February 27th, and then $1,500 more by April 1 and the 1st of every month thereafter until paid in full. You understand that, Mr. Robertson?
Yes, sir.
Ms. Robertson? And again, you agree to those terms?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. And you have until March the 5th to appeal.
He's on the phone, still trying to work it out.
All right. Thank you very much. You can all go down the hall and get a copy of the judgment for your records. Best of luck, folks. Thank you.
very much, Your Honor.
Thank you. So this has to go down, John. Butlers. Jennifer. Was that? Yeah, Anthony Butler versus Paul Robertson and Shauna Robertson. This is 2600122. Everybody's name.
Anthony Butler,
Skylar Crenshaw.
Shauna Robertson.
Paul Robertson.
Do I have a copy of the judgment in this file, Jennifer?
Judge, I'm not sure if we printed it, but I can get it really quick.
Would you do that for me, please? Now, I know that they probably gave me bad information down in the civil department. I'm sure they did. But I don't want to say anything until I see the judgment. So they're going to bring the judgment to me, and I just know that you guys didn't miss a payment, Mr. and Mrs. Robertson. You wouldn't do that. That would just convince any judge that has the ability to count to three. They would recognize what kind of game you've been playing this whole time. I just want you to know. So I'm sure they didn't update me. I'm sure you guys paid. I just need to wait for the file to come here, and you ought to be completely ashamed of yourself if you didn't pay on time, and if the civil department didn't update me because the payment was made a day or so later than it was supposed to be. I know you would be ashamed. I would be ashamed. I wouldn't want to walk out of my house, but that's me. So I don't know what's going on over there, but I think you guys just have taken this and prolonged it. But I will reserve judgment until they bring me the files. All right. Anthony Butler versus Paul and Shauna Robertson, 2600122. You can read this. Everybody's name.
Anthony
Shauna
Butler,
Everybody's name, please.
Anthony Butler,
Skylar Crenshaw.
Shauna Robertson.
Paul Robertson.
You guys pay these people or not?
No, we didn't.
Shame on you.
Well, there's more to this situation that's still not being said, but I have had, my husband was hospitalized. He has ongoing health issues right now. He just got out of the hospital and since then lost his job. So this isn't just us not wanting to pay. There's bigger things to this, and we've been saying that all along, but it's not being heard and nothing's...
And just like that, everything unravels. The tenants admit they didn't make the agreed payment, and the judge's tone shifts instantly. This is no longer about mold, inspections, or misunderstandings. This is about breaking a court-approved agreement. The tenants bring up job loss and medical issues, which are real and serious, but the judge points out a key fact. Those events happened after the payment was already due. Legally, that means they don't excuse the missed obligation. And now, the judge sees a pattern, not hardship, but delay. That's why the reaction is so strong. Because in the court's eyes, this isn't confusion anymore, it's noncompliance. So here's the big question. When you break a signed agreement, does anything else even matter anymore?
Heard and nothing's being taken care of. In the process of us trying to move out, which that's the process right now.
Slow down.
The basement has flooded once again.
Slow down. Now you're going to get aggressive with me, huh?
No, I'm not. I'm just really upset because I feel unheard.
Stop. Don't tell me this stuff about not being heard. You want to tell some judge that, some court, you tell them that. I'm not going to listen to that. I heard everything that went on. You guys reached this agreement. You were supposed to pay, and you didn't pay, and now you want to get aggressive with me? Are you kidding? You think I'm going to listen to this? Stop. Do not interrupt me. Do not interrupt me. I feel like it hasn't been heard. Nonsense. I listen to every word that comes out of every person's mouth, and I give them multiple opportunities. And now you want to start to be aggressive the other way because I'm calling you out on going back on your word? Seriously? Don't play that game with me. Do not play that game with me. I can see I've been doing this too long.
And I don't mean too long where I can't do it. I mean too long where I can read everybody like a book from cover to cover, and you guys have been playing games with these people. That's what you've done.
Can I say something, Your Honor?
No, no, you cannot.
Okay.
We were prepared for trial. You guys resolved it. When did all this happen? I signed the judgment on February 23rd. When did he lose his job and when did he go in the hospital?
He lost his job the week, 2 weeks after the judgment, and he was in the hospital all last week.
Do you work?
Yeah, I work midnights.
Where do you work?
I work at Henry Ford St. John down in Detroit.
All right, well, here's what I'm going to do, Mr. and Mrs. Butler. I can't really go back on this. You got a money judgment for $9,500. They were supposed to pay you $2,000 by February 27th.
Bye-bye.
Which was after he lost his job, right? Was that after he lost his job?
Yes.
So him losing his job had nothing to do with the fact that you didn't pay the $2,000 as agreed upon, did it?
No, but we have.
Well, then why'd you try to put this off? It's nobody's listening to me. Don't play that game with me. That had nothing to do with anything. I mean, you don't have to be a legal scholar to see what was going on this one.
Your Honor,
Folks, here's what I would do. I'm not going to listen to this. You can't, based on the fact that you did this on your own, you can't have a writ issued until they have to move out by March the 31. I'm going to tell you what I would do. I would come in here the morning of April 1 with an application for a writ. Jennifer, you're going to tell me I'm coming down there and signing it, and you're going to have the bailiff ready to go out and execute on that judgment on the 1st. That's number one. Number two, I would subpoena them for a creditor's exam, both of them. And then they're going to have to come in with all their documents and all their wage info and all their bank accounts. And then you can start garnishing her wages. And when he's employed again, his wages. That's it. I wanted to just call this up because I knew you guys called the civil department and asked what I could do. I looked at the judgment. I said, I knew they were being duped. And actually, it was probably my fault for not advising you better. And I don't want to advise either party. I'm not supposed to do that. But I saw this thing coming here. So that's why when I hear somebody get aggressive with me, I'm not going to be quiet about it. Enough said. That's the end of that case. Thank you. People against Tarek Anthony Kuczynski, 22F237131. Good morning.
Good morning.
This case is a perfect example of how quickly things can spiral in court. It started with claims of unsafe living conditions and unpaid rent, but ultimately came down to one decisive moment, a signed agreement that wasn't honored. The tenants raised legitimate concerns about the property, and there were signs that issues may have existed. But once the court reset everything and both sides agreed to clear terms, the focus shifted completely. When those terms weren't met, the judge had little room to maneuver. The result? Enforcement of the $9,500 judgment, eviction proceedings, and potential wage garnishment moving forward. The lesson here is simple but powerful. In court, agreements are everything. Once you sign, your word becomes law. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.